Maneva na sema PENDREAM TV. PENDREAM TV there osia dem yopo.
Good. Now, Mr. Okanse, when it comes to these petitions, if I'm not careful, I'll be shooting from the hip. Shooting from the hip because, you see, we are all handicapped in the sense that we don't have the petitions. So it's, and you know, in the...
No, Honorable, please, let him in. I'll give you the time to answer, please.
Maybe it will enrich there.
No, don't worry. You will still ask that question because you are just started speaking. So maybe you end to a point. Let him end the statement so that I'll come to you.
Okay.
Please.
Yeah, so we are handicapped. We are shooting in the dark. We've not seen the petitions. I tried calling one of the petitioners yesterday, but he hasn't responded yet. So let's see. Mr. Havo. Yeah, I think Havo is one of them. No, he's a petitioner under the Justice Derry case. Okay? Justice Derry and others versus Tiger PI, Attorney General. The Supreme Court said after the hearing, the cloak of secrecy vanishes. Yeah, so now we can publish the petitions. So please, the petitioners, bring the petitions forward. Let's analyze. So right now, strictly speaking, it means that we can have a sensible debate on the matter without the petitions.
Okay.
There's a temptation to hazard a guess, which, sometimes we will take educated guess. So if you agree, the educated guess is that the matter of SAL featured in the petitions. And if the matter, that's Santro Kofi Akpafu Lolobi, right? They didn't get an MP. They did not vote in the 2020 elections for an MP. So they didn't have an MP for 4 years. That matter, if we all accept at the table that as an educated guess, that matter made it into the petition, I'm surprised that the petitions were thrown out. Because the SAL matter is something that at least it should have gone to trial. That one I can say unequivocally. If we agree that as an educated guess, at all costs, the SAL matter made it into the petitions, then I really struggle to see how the petitions can be thrown out. So I can't say, but you see,
but we don't know.
Yes, that's why I said yes. But I'm saying as an educated guess because that matter has been beaten in the public domain, sir. And then second educated guess, the publication of the 2020 elections results 5 times. What's a comedy of errors? 1 election results, 5 publications. They publish 1, there's an error, then they withdraw, then they correct, republish, number 2, error, withdrawn, then republish, number 3, up to 5. It was a comedy of errors. If that doesn't speak to incompetence, what else can it speak to? Number 3.
No, the previous point you wanted to make.
Yes.
Are you? No. Yes.
Let me ask you the question. 7 petitions against who? Because you are talking about 3 people. Who are the petitions directed at?
The 7 petitions were against the EC and her 2 deputies, and 3 against the special prosecutor.
Article 146 expects an individual's petition against an individual. So when you say it's against 3 people, who are the specific petitions against?
Right.
We cannot petition against the commission as a group. Or as an institution. It is directed at individuals within that institution.
So who doesn't have that information? But
by interpretation of law.
No, I'm saying that we can proceed without knowing that nitty-gritty, the
No.
general idea. For
You
our
should
purpose.
know who is responding to which petition and the issues in the petition directed against a single individual, so that the CJ had an opportunity of looking at the petitions against Apiekubi, the petition against Martin Pebu, the petition against, and the issues could be different.
I see.
So for our purpose, I think we can assume
that's why we are talking about.
Yeah, but you cannot petition against the.
No, I think that point is well made. But all of this comes back to the point you made that we don't have the benefit of the details of the petition.
Yes.
So that's the limitation. I hope you agree.
So we've put in the caveat that we are doing an educated guess that these are the matters that we raise against the EC and the deputies, right? Okay. And let's put it in context. Very important. It's good Mr. Ahiagba is here. The MPP has agreed that Jim Mensah must go. She's not fit for office. The NDC
have they agreed?
Yes.
No, wait.
Justin Kodria.
Because you are putting,
Yes, a personal opinion.
And you haven't reprimanded him.
No,
you haven't Justin Kodria, let's Google it. Justin Kodria.
No, but that point is not even valid. The NDC wanted the hair gone. What didn't they say that? They wanted it gone, so does that mean that they certainly by that they should go? No. It's the law that must work. It's not what somebody says. Yeah, it's the law. So if somebody says that, they're expressing their personal opinion.
So the point I'm making, see, we are trying to create the context.
Let lawyer Martin Pebu, let him end because
I'm saying that NDC said Jimesa should go long time ago.
Thank you.
That means you should go by their
Thank you very much. Lawyer Martin Pebu,
The prodigal son. This prodigal son that went
move on, please.
The prodigal son is back to cause trouble again.
Move forward.
Okay, all right, yes. So we're saying that look, this is a management team that both NDC and NPP agree must go, and we know democracy is crowd wisdom. So you see the context, and that no wonder after the decision, I've received many calls. WhatsApp messages. People are upset from both camps. People are upset. So listen, we have to be careful. We have to be careful. Look, we are citizens. It's crowd wisdom. Democracy is crowd wisdom. The larger majority of public discourses have gone against the EC chair and the deputies. And so if we're saying that the biometric register we did in 2020 had to queue up in COVID, etc., endangering people's lives, then publishing results 5 times, etc., are not enough for Jimensa and her deputies. Bosman Asari, who said NDC is an existential threat to our democracy, etc., then I don't know what again will qualify. So this particular thing, I'm sure people will represent petitions. No, people will represent. Because look, one thing is clear to me, that this management team of the EC, the Jimensa and her 2 deputies, cannot be at the helm of affairs come 2028. Look, the more you keep them in office, it's as if the whole of Ghana, we don't have enough talent. Because those people in office, that's our best too. Public office is for the best of our best. So this telling us that 34 million, Professor Jampo sits here, etc., was Bosman Asari not your colleague? Even he was a year behind you or your classmate. Mates, right? So what is it that is in Bosman Asari?
So you say the door is not shut?
It's not shut. Okay, I'm sure there will be representations of petitions because the groundswell of anger at the decision, etc., it's clear to me that there will be new petitions presented and hopefully those should go through. Because one thing is very clear, that Jane Mensah and her deputies cannot be in charge come 2028. We can't. This is Ghana. Ghana, you see.
Law, right?
But what law?
Not wishes. It's not.
By what law?
If the chief justice says
when it comes to,
he's the lawyer. He's the lawyer.
The saving grace is that the chief justice has only less than a year to live. In December,
how does that impact on the?
Yes, so new petitions, you get different mindsets. Yes, hopefully. Yes, because
so are you saying that hold on? Are you saying that the chief justice is guided by law in arriving at a particular decision? It's not by his own whims and caprices.
That is true. Yes.
Yes, the law, you see, yes, so he is doing the analysis. Yes, it's subject. Yes, exactly.
That's why.
Yes. Yeah, no. You see, the thing is that when we say guided by law, in law.
No.
Exactly.
I want to hear one person.
Look, in law, we have different philosophies. You see those who are positivists, then you see those who belong to the natural law school of thought, then you see the sociological jurisprudence, etc. So you see 2 lawyers seated. And then different minds, the same law, different minds, right? So we don't help the debate much when we just say it's law. It's a lot of personal idiosyncrasies. Law is guided by a lot of personal idiosyncrasies. Yes, a lot. A law leaves a lot.
But in this instance, how does the Chief Justice's own personal biases or idiosyncrasies influence an outcome like this?
We don't have much. That's why they always say when you write less, when you speak less, there's no opportunity for anybody.
Because you said
I'm giving general
think differently.
I'm giving general education
that the purposive approach.
Yes, that's what I'm saying. Different schools of thought, right? So this one is Chief Justice hasn't written much. I'm hoping that there will be a lengthy ruling addressing all the specific points. Because let's always remember, Chief Justice Bafubwani, yeah, we support. Bafubwani suffered a lot. You know how Nebuchadnezzar ostracized him, banned him from Jubilee House, etc. He suffered a lot, but thank God eventually he became Chief Justice. But Chief Justice Bafubwani, this one there, we beg you, we want the longer ruling.
All right, no, please, gentlemen, no, please.
Yes.
Counsel, no.
Okay.
Please.
Okay. Yes. So what we are waiting for is that there will be a lengthier ruling. That's my expectation. The one that will address the things point by point, so that we can analyze. You see, like the one Akufo-Addo wrote. Say Akufo-Addo's ruling on the prima facie, lawyer Okujeto came out to say he wrote it, and Akufo-Addo reviewed, approved, and signed. So
you want something of a sort?
Yes.
Detailing.
So, yes, because you see, let's improve the standards. The Supreme Court said as far back as 2004, the Chachuchikata case, that when a decision maker, a judge makes a ruling, just have dismissed this without giving the details of the reasoning, you give room for people to think the decision is biased, the decision is malicious, the decision is thoughtless. I've been repeating this point. This point is one of my crusades. We have to keep drumming it that this removal Article 146 proceedings will get full rulings. These are serious matters. I also know very well that the Chief Justice, the work is a lot. Chief Justice will empanel judges, administration, sit as a judge, etc. If you read Professor Dateban's book on the Supreme Court's jurisdiction, it even tells you the way Ghana's Supreme Court is inundated. Too much work, in simple terms. Yes. So you can see that because the Chief Justice has a lot of work, sometimes then there will be the tendency not to write lengthy rulings. But our Ghanaians, as we are now, we've evolved to that stage where it's the lengthy rulings we want to deal with. So today, if you Google, you see Akufo-Addo's long ruling. He gave his reasons, and we also went in there. The ones we agreed, we show excellent. So that's the standard. So it's becoming clear that this Article 146 proceedings, etc., are going to inundate the Chief Justice.
Is it one that you want amended?
Yes, so we have to amend and relieve the Chief Justice of such work. So that the Ethics Commission that Professor H. Kwesi Prempeh is suggested in his constitution, the committee is suggested, maybe we can give that work. Or set up a full commission for the Article 146 proceedings, things, so that they can give us detailed rulings. Because 5, 7 lines, 10 lines is not enough. This Ghana, where, just like the way we have 34 million coaches, that's the way we have 34 million lawyers. 34 million lawyers waiting to read. When they see 10 lines, no, it's not enough.
Something detailed. Thank you.
Excellent.
This is reset gone bad. Reset gone bad. Hearing about Tikwebu saying that essentially what we have here is a setback is interesting. That this cannot be happening in Ghana. We're supposed to you that yesterday we had a better situation. You understand? Let's go back. Mr. President, bring back Justice Gertrude Tokono. This is a setback. By the analysis, it's a setback. Let's proceed in the direction that we're going. It's a setback. I'm saying, but no, we're doing educated guess. Is that not what? Yes. So I'm saying that by that educated guess, this is a setback. And it's very revealing. Okay? Now, my comment will be in twofold. First of all, this whole release of this no case against EC and special prosecutor, the first leg is that throw this in to muddy the situation against the cocoa matters. Quickly, just throw something there. Everybody say, oh yeah, but I didn't find any case, and therefore MPP, whatever. That's what. So its purpose is to stop us from talking about the cocoa. Okay, and thanks to you and the good relationship that you are forging ahead with Ghanaians to give them what they want to hear has made us speak about cocoa. Because if you look in the space today, your contemporary programs today, they are not discussing cocoa. They are discussing this. The objective has been achieved. So this one stamps up to TV3. You understand? So the truth of the matter is that this one is an agenda to put it out there to quench the cocoa matter, which is not going to go, because really the cocoa matter is a personal everyday issue for the cocoa farmer. So that's not going to go. So the first thing is that it was an obstruction they threw out there, and it didn't work. And the reason it is an obstruction is that lawyer Martin Kpebu is a big guy. He's a big lawyer. A big lawyer. And Chief Justice should know that's lawyer Kpebu's petition. He has not dealt with that one. So why do you hurry up and bring this when you have not finished dealing with all the petitions? So what is likely to happen? He brought out about no case against special prosecutor, no case against EC. So, but then his petition is still outstanding. So what's going to happen to that petition? What will happen to your petition?
We are waiting for it.
You understand?
It will come out.
Yeah. So, but it's clearly not regular to do that, because you receive a certain number of petitions to do a certain amount of determination about two separate issues. You have not finished with all the petition, but you have released your report.
Oh, mine went later. So maybe he wants first in, first out. You see the queue.
But it's the same issue. Okay, so yours will be determined later. So we should wait for the special prosecutor to be removed when yours is considered. Yeah. So the point is that this is done because they wanted to disrupt the issue. But the point I am trying to wonder about is that...
do you make an emphatic...
The point you have made, Prof, you made emphatic statements here when Akufo-Addo was in office, the kinds of things. In fact, I'm not going back, I'm just on the point. What my good professor and lawyer Kpebu.
You said you are going forward.
Yes, I'm going forward. You are here, so
because then I will respond.
Yeah, I'm coming. It's a point.
You reference a statement that was made by your chief scribe.
Yeah.
Does it represent the position of the party about the EC chair and her deputy?
Just put that point on ice. What I'm trying to say is that...
Why are you determining
wait, hold on.
He's taking me back.
Does it, because in the midst of that, you try to clarify the position.
Yeah, I'll clarify it.
Does it represent the position of the party?
I'll clarify, but I'm just saying that, listening to lawyer Kpebu and Prof. Jampo today, I wonder if they know President Mahama is the one in government. They are still talking about Akufo-Addo. You understand? Okay. They should deal with President Mahama the way they dealt with Akufo-Addo. The integrity matters. And I think on this matter, on this law thing, I think the Kpebu is coming along. But Prof. Jampo, I'm expecting, on this cocoa matter, he was all over the place talking about MPP. I'm not going back. I'm just saying. I'm just saying. He's not talking about MPP as if President Akufo-Addo was
But you see, you have to appreciate the problem, the cause of the problem, and you tell the cause of the problem that it does not lie in your mouth. You don't destroy something. Somebody is fixing
the cause is in opposition.
Listen. The cause is not in office.
Your mouth
you don't tell the problem, and when somebody is fixing it, you become the one detecting how the person is.
We are on this one. We are on this one.
So when I'm saying defecate on yourself, leave the place smelly, and then somebody is wiping your mess, and then you are saying that you are detecting how the person is.
You are supposed to wipe it. You say you can wipe it.
Please. So when it is being wiped, you don't detect.
You campaign for the person who said he will wipe it. Now he has come, he can't wipe it, and you are talking about the person you said could not wipe it. So what does that make the person who has come now?
But you are detecting how he does the wiping, and I'm saying that is unfair.
It's okay. No, but you are the one who campaigned for him. He said he can wipe it. He has come, he can't wipe it. Tell him he said you wipe it.
You are detecting how he wipes it.
But you should tell him. You should tell him. But you campaigned for him. So you should tell President Mahama you messed up by doing what you have done. You can say, why are you talking about
MP? It doesn't lie in your mouth to detect how the wiping is done.
No,
it doesn't lie in your mouth.
In fact, the point is that we could have just talked about cocoa.
No.
But we'll talk about this. Yeah, we'll talk about this. But I'm just saying that. Just so my good professor gets back on point. What we have before us is a government that is supposed to be delivering for our country. When they are doing it well, let's say. When they are not doing it well, let's say. But let's not be talking yesterday as if Akufo-Addo is saying government. When the campaign you did led to us losing power. So now today we have a government that must deliver for Ghanaians. Okay. That government is not delivering for farmers.
And
we are talking to that. I'm coming to that, right
it has nothing to do with
so if you don't come to the studio and talking as if Akufo-Addo is still in government and forget that the government that is there today is failing. That's the point.
Okay.
He should talk about the failure of the government because it affects all of us. So do that. So the point is that this whole EC matter is much ado about nothing.
No, I asked a specific question.
Yeah.
Your general secretary made a statement.
He didn't speak for the party.
Okay.
It was not the party position to be communicated. He said his bit. You understand? MPP didn't say that we want Jimesa to go. We didn't say that. You understand? By the way, the NDC in opposition says the Jimesa would go. In fact, they said she would go. Why is she not gone? Because it's the law. You have to go by process. And that process, begins with the Chief Justice. And the Chief Justice says he doesn't see any wrongdoing. It's not anybody's place to say that he must go. Somehow, Lawyer Matikwebu thinks that they must go. Personalizing the issue and say, oh, what is in Dr. Bosmasari's head that is not in my own professor's head. That's not the point. Prof. Jampo can do a better, splendid job, but the point is that before you remove whoever is there to come and get Prof. Jampo to come and do the job, you must go by law. And unless the law allows for that to be done, you can't force it just because you want it. So Lawyer Matikwebu's appeal to emotion to get the Chief Justice to revisit the petitions and do otherwise, for me, is neither here nor there. But we are just watching. The point I want to make, which is confirmed by Chief Justice Bafubodi's position on this, the no case finding that is brought to us, is that Chief Justice Gertrude Araba Esaba Tokonu, there was no case against her to begin with.
That's how you see this?
Absolutely. There was no case. But somehow President Mahama, with the interests and the political motive they had coming into office, engineered a removal. Chief Justice Bafubodi, based on what? Because when we're campaigning in 2024 and the utterances of the NDC, who, between Chief Justice and EC, who do you think the NDC wanted to remove more?
But if you
understand, they wanted to remove the EC. There was no evidence of them wanting to remove Chief Justice. But they came and saw that the agenda would not materialize if the Chief Justice was there. So they went and fabricated matters. Things that were not on the scale to be considered a misconduct.
But if you read the Chief Justice, the letter that was written,
I'm coming against the good counsel of the Ghana Bar Association, the Commonwealth Lawyers Association, saying that what you are doing is not proper. When you say, they come and tell you, oh, where in Article 146 have they gone wrong? Article 146 is a procedural thing, is a law that provides for a certain action to be taken, right? But the motive that you activate is not accounted for in 146. Okay. So their motive, by all means, engineered by the petitions they have come, and by President Mahama, being the man with whom the buck stops, determined that they must go. There's a case. So was it. But that's about what he says. There was no case. So if you bring today, if you take the petition sent to President Mahama for the removal of Chief Justice Tokonu, Justice Bafubodi, perhaps by this standard, we say no, there's no case.
I see. But,
so
but
in any case, we are not too long.
Details of the petition.
I'm saying that. But the political narrative about EC, you see what the lawyer was saying? I'm just saying I don't have to see it, but I know what is perhaps in there based on the NDC narrative.
I see.
You understand? So right now, what we ought to be doing in Ghana is to appeal to President and say, look, it's not too late. We've offended Justice Tokonu. The fabricated petitions and all the flimsy stuff that were manufactured and magnified to mean misconduct.
That's why I said
ought to be reversed.
I asked
and
if you have seen the details of the petition, and so you haven't seen it.
Which petition?
So on what basis are you saying that?
Which petition?
I'm
talking about the Chief Justice petition. The cases. We had the details of it. She hasn't done. I'm saying that she hasn't done anything that is on the scale of a removal of a misconduct. Based on the standard that must be met. I'm telling you, hold on. Let's not go into that. I'm just telling you that.
Standard is that?
I'm just saying that the high standard that Justice Bafubodi has set,
which is
to say that the offense or maybe the claim made against the officer must be egregious enough to constitute a basis for the removal. You understand? So what they brought against Chief Justice Tokonu does not measure up. And that's why the Ghana Bar Association says, so please don't proceed. Even what constitutes misconduct is not properly defined.
All right, so
it's not properly defined in light of Article 296. It's not properly defined.
Here's what I bring in.
So right now, what the president ought to do is to say that let's bring back Justice Coürt, because in fact, he still have case in I think it's a Commonwealth Court or even in our court trying to challenge.
That's your expectation.
Vein removal.
So I'm reading this letter that the presidency wrote to one of the petitioners. A part of it says, and I quote, and this they are referencing the Chief Justice's letter on the 26th of January. While the allegations raise serious constitutional and administrative questions, according to the Chief Justice, they do not, on their face, meet the threshold required for prima facie determination of stated misbehavior or incompetence warranting that the next stage of a committee being set up to inquire into the petition actually even happens. So the petition largely rests, based on the verdict of the Chief Justice, on conclusions of unlawfulness and bad faith without establishing at a preliminary level clear facts demonstrating intentional wrongdoing.
Good.
Would you subscribe to that proposal of this getting further and better particulars as to why this conclusion was reached?
Well, it is important to be informed so we can speak to the issues and the facts and relate it to law. So the details will be necessary. Notwithstanding that, I pointed to you the anomalies as presented to us. I'm not saying because I haven't seen the petitions, but the anomalies as you have related to us because of the ambiguities in the persons being petitioned against and for what reasons. And trust me, if you go through the petitions, you will not see the same wording of the parties petitioning in the petitions. So that is why it is important to look at it and see on which grounds are they petitioning against. But it looks like it is an omnibus thing, petitioning against either the whole institution of EC or some of them together and others on their own. That is the difficulty I have. But if you look at all that under Article 146, it is the Chief Justice that makes the determination. But if you equate it to the case of Madam Justice Tokonu, the deciding body was the Council of State. So you should know that there are two different institutions making a decision by way of advising the president.
Right.
So it cannot be the same. So again, if you look at the constitution of the Council of State, you realize that most of the members are appointees of the government, appointees of the president. And therefore, it cannot be equated to, again, an independent Chief Justice. So let's take the work of Chief Justice as coming from his position as Chief Justice and an independent one as such. Then he is confronted with these petitions to make a determination in advice to the president. And he says that the minimum threshold, and don't forget, it is not proved by the preponderance of probabilities, and again, not by proved by all means that it is fallacious, but it is the minimum standard, prima facie case. The standards are different. Beyond reasonable doubt is quite different from this one. And he's saying that based on this threshold, even the minimum standard could not be met by the petitions. That is what Chief Justice is saying. And for which reason there is no need at all to proceed further in the process. And this is akin to the submission of no case. The standard is so minimum that if you don't meet those thresholds, and the last words of my Lord Chief Justice, he says, intentional. Granted that in the process you can even identify some shortcomings. What Chief Justice is saying that you cannot allude to the intentional conduct of misbehavior. And therefore, if there was some element of misbehavior at all, and you know, in the criminal world, it is actus and mensa. He's saying even though mensa could be, the intention could not be deduced to support the mensa. And therefore, he says that they couldn't pass the elementary test. I'm not privy to the full context of the petitions and all that, but who am I to say that a Chief Justice could not get it right? And indeed, if you look at the submission he's making, is addressing the totality of what he, in his view, constitutes a commission of a crime or commission of a misconduct. And he says that even if you find anything inconsistent with the operational expectations of the law, he doesn't think that these were committed out of intentions to commit crime or commit misconduct. So I have no reason to doubt the competent integrity of the Chief Justice. No. So he has a constitutional mandate to interrogate the petitions and come out with the advice, and he has so done. And I think that we should take it as he has done and move on in life. Martin was talking about a possibility of influx of petitions. Yes, it is possible, but that the determination of one petition does not necessarily stop other people petitioning against the same persons or different persons. As and when there is a petition of quality that comes, the Chief Justice, as under the Constitution, have the obligation to determine it. And when that is determined, he has done his constitutional duty. So I think if the 100 more petitions will follow, and looking at his schedule of work, and Ghanaians who want to take him away from his core function and let him consider petitions, that's for him, he has nothing to do. As and when they come, he will sit and also make his mind, and then advise the president as required by law. So I am not, in fact, this decision is also telling Ghanaians that don't waste too much time when you come with frivolities. Make sure that you have evidence to support the cases we bring to him. And the nature of the game is evidence. So the Chief Justice of all people has taken the time to look at the petitions that come out with a decision. I don't think that we have to belabor the point. Chief Justice has a constitutional mandate to do what he did, and he has given us his opinion. I think he has finished.
Okay, thank you. Prof.
Much should have done.
Okay, so thank you. You see, as Martin indicated, for the first time in Ghana's political history, this is the first time that the political elites, or the two main political parties, were ad idem about the call that the EC chair should just be shown exit. This is the first time that they were. Oftentimes, oh, my friend.
Prof.
No, there are things that you said. I want to respond, but I've decided not to. I've decided not to respond, so you allow me to flow. So this is the first time that I'm saying that the political elites have been ad idem in their call that the chairperson of the EC must be shown the exits. This is the first time. And the other point that must be made is that you recall that when the MPP wanted Charlotte Osei ousted, they ensured that she left. NDC people said EC chair should go. MPP people said EC chair should go. They sent it to a CJ that an NDC government appointed. The man has looked at the merits of the case. And of course, I can understand, given that even the political elites were all in agreement that the EC chair should go. I mean, it's fueled, or it still has fueled people's reaction that they don't understand.
I mean, if NDC people say you should go and people say you should go, then why is it that? So I'm monitoring feedback from grassroots and all that. People are not happy at all. No, people. It's important. People are not happy at all. But the point, as you have made the point earlier, the determination of this one case does not stop those who think that they are not happy from sending another petition if they want. Okay, the door is not closed if they want. But for me, what is important in this is the fact, I'm thinking about governance and democracy in Ghana, is the fact that judicial independence has been restored. When we talk about judicial independence, we are talking about absence of bias on the part of judges in the discharge of their duties. We are talking about absence of external control and influences, on judges when they are discharging their duties. And then you're also talking about the delivery of judgment by justices of the Superior Court without fear or favor, with all boldness. That's what we call judicial independence. And this has been restored. Okay? Now, you see, gone are the days when people could have a priori knowledge. If you say a priori knowledge, see, foreknowledge about the outcome of cases that you could send to court. So people easily say, let's go to court. The slightest provocation, let's go to court. What do you know? Who do you know? Who have you planted in the court? The slightest, let's go to court. And anytime they said, let's go to court, they got the judgment that they were looking for. Now, you know that you cannot just be saying, let's go to court. Whether you appointed a CJ or not, they would look at the merits of the matter to determine it. I mean, there's a Pandai elections and all. I mean, people were like, is it the judges that we know? Is it our courts that are now behaving like this? And I'm saying this is very good for democracy. If you send a matter to courts, okay, the processes must be allowed to operate, and the days of unanimous FC should be buried in the garbage of history. Now, judges are seen as people who, when the facts of the matter are brought before them, they look at the merits and then they give their judgment. And for me, that is very good. It tells me that it appears that look, whether the president of the republic likes it or not, there's nothing that he can do about this particular thing that the Chief Justice has come to say. The only thing that if anybody is not happy will be to petition again. But CJ has given his ruling, has given his advice, it's written, and the president is bound to accept it. And you can judge. People are angry, and some people are saying that, they should have screwed the processes and all that. That is not part of reset. Reset is to go back to how things used to be, and then also possibly to improve upon things. And I'm happy. Okay, even though, like I said, a lot of people think that look at the MPP when they wanted Charlotte Osei to go. They made it a campaign promise, and when they got into power, they ensured that Charlotte Osei was shown the exit. But in this particular instance, my father used to tell me. My father used to tell me in this particular instance, please. My father used to tell me that police if a police officer does not want to arrest you, it means he doesn't want to arrest you. Okay, if people wanted to manipulate things and all that, they would have succeeded. But we have reset the country such that no, please. The country has been reset in a manner that now hands off, the presidency, the ruling party. They send matters to court. We are not interested. It is not like previous time where people, top echelons of a party would, at the slightest provocation, will be there, if you like, go to court. And then when they went to court, they go to court, matters that ideally should take months or weeks in tabling. They go to court, and within 1 minute, they get the Supreme Court, the court's justices to sit on it and all that. I mean, these things have weakened our institutions. These things have weakened our judiciary. And I'm happy that though some other people are expressing dissatisfaction,
generally, the principle or the idea of judicial independence has been restored. And do you know what it means for democracy, for judicial independence to be restored? Do you know the number of investors that even this, okay, when people are coming to your country to invest, one of the things that they look out for in investing is the level of independence of your courts. Because they don't want a situation where they come to your country and then a government just gets into your business and say, I've nationalized it, I've confiscated, and the judges are in bed with the government and then you take over. So the point is they look at the level of independence of the judiciary. Sure. And that is, so it means the idea of judicial independence is in itself a tool for development, because people will look at it and decide on where to go to invest, in a country. And so for me, it is good. Those who are not happy, the door is not closed, like you said. This determination does not stop anybody who thinks that. I've heard the argument, and you are saying you are not even sure whether it featured in the petition because we have not seen it. But people have raised several whatever, but the point is that they are not stopped. If you are not happy, you can go again. But to the extent that judicial independence has been restored, I think I applaud the process, and I celebrate the Chief Justice for being bold, knowing that this thing that I'm going to say, it may see sometimes judicial. I studied a course in the U.S. called judicial politics. Sometimes judges are also mindful of the likely public outcry that may come. It takes it takes a bold judge, a bold Supreme Court judge, or a bold CJ to say that I know whatever I'm going to say may be unpopular or among some people. It may even be unpopular among the ruling party and those who appointed me. But the stability of the state, and for the sake of doing what is right, I will do it, and then save the nation and restore a certain level of respectability and credibility to the judiciary. And I think that I commend him, I applaud him for what he has done. Let's move on as a nation. Like I said, the door is still not closed. If people are not happy, they are free to. They are not stopped from going back to present whatever petition that they have.
Thank you. Since you made the point that your petition is yet to be determined.
Yeah.
Would you be surprised if it takes the same path?
I'm laughing. I'll be extremely surprised.
That your petition will be thrown out by the CJ?
Yes,
it doesn't meet the threshold?
Yeah, no, there's no way I'm taking a cue from this. It will be fight, hey.
Fight us in how?
It's not the law.
Take a cue.
No. Each case is different.
Must win.
Yeah,
that's why I'm asking.
But at least if you look at my petition,
okay, it should win.
It contains a lot. So no matter what, at least if you should stick, it contains a lot. So to be able to.
So you'll be surprised if the CJ says, look, based on all of it, there's no basis to activate the machine. It doesn't meet the preliminary or the minimum threshold.
Absolutely.
On the face of it.
Yes, absolutely. Because you know that. Look, as I said, in natural fact, let's mention this. As I said, we want to respect the Chief Justice's role. I mean, in doing the prima facie, etc. That's how come we've not published the petition. Otherwise, you know that under Act 959, the Office of Special Prosecutor Act, there is no provision for secrecy. When you read Section 16, which deals with petitions against the removal of the Special Prosecutor, there is no provision for secrecy like what you have in our.
I'm not PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.